Hello, everyone. Today we have interpretation. In a few seconds, you're going to see a globe at the bottom of your screen. Please select your language by clicking on the globe at the bottom of your screen. Or if you're joining us from your cell phone, click on the three dots on your screen and select your language. Hola a todos, en el día de hoy tendremos interpretación independiente de su preferencia lingüística. Le pedimos que seleccione su idioma haciendo el clic en el globo terráqueo, el cual aparecerá en la parte inferior de su pantalla. Si está con nosotros a través de un celular, por favor presione los 3 puntos y elegir el idioma en el cual desea escuchar la presentación. Gracias. So you can...
Thank you so much. And everybody should see a globe at the bottom of their screen. So choose English if you need English and Spanish if you need Spanish. Everybody must select a language because we're doing live interpretation right now. So thank you. All right, we want to welcome everybody. There's a lot of you here today, and we thank you for being here to talk about this very important topic. This is part one of a 3-part series that the Connecticut Parent Advocacy Center and the Connecticut State Department of Education are doing in partnership. And we have today with us our colleague from the Office of the Child Advocate, as well as a guest panelist that'll be presenting with us today. Laura, can you go to the next slide? Thank you. So we'll start off by introducing ourselves. So I'm Jennifer Lucier. I am with the Connecticut Parent Advocacy Center, and our role is the federally funded Parent Training Information Center in Connecticut. And it's, even though we have the name Advocacy, the word advocacy in our name, we really are tasked with empowering families and educators to work together and building their capacity to understand student rights and the special education process and how to be collaborative partners. And I'll turn it over to Sean to introduce himself next.
Good afternoon, everyone, and thank you for joining us. I'm Sean Cronin. I am from the Connecticut State Department of Education. We are the state education agency here in Connecticut. And I work in the Bureau of Special Education, and I oversee restraint and seclusion for the state of Connecticut. So I'm going to turn it over to Virginia Brown now from the Office of the Child Advocate.
Hi, everyone, and thanks for having me. I'm glad to be here today to discuss this very important topic. I'm with the Office of the Child Advocate. I'm the staff attorney there, and in addition to providing legal advice and guidance to staff, I also work on education matters. The Office of the Child Advocate, of course, is an independent government agency that is statutorily required to review complaints of persons concerning the actions of any entity that provides services to children through funds provided by the state. And with respect to my work, primarily that has to do with school districts, private schools, public schools, and such. So thanks, everyone.
Thank you. You can go to the next slide. All right, so for today, this is one of 3 series that will be one of 3 in a series that we'll be doing. We only have an hour and we have a ton of information to share with you today. Even though we're going to be discussing the laws, and even though one of our presenters is an attorney, we just want to emphasize that today is an informational session only and not to be considered legal advice. This is being recorded and it will be posted on CPAC's YouTube channel. And we really want, with this webinar series, to be able to share accurate and objective information for all stakeholders, aligned with Connecticut's family engagement framework, really being able to share the same information with both educators and families at the same time so that we all have the same foundation of knowledge. We will be sharing, the PowerPoints will be sent out to participants following the webinar, and you'll have access to all of this information and the links as well. This is a forum that's really meant to talk generally about the law. So we will not be talking about individual cases, but we will share resources with you at the end of this session. If you have an individual case that you need help with or want to discuss, And as always for CPAC, we are a parent training information center. So we do have a call center, and our number and our email are up there, and they'll be at the end of the slide as well. I mean, the end of the presentation as well. Go to the next slide. So throughout the presentation today and throughout the series, there will be a lot of acronyms. The law is very heavy on acronyms. There's a lot of information. So some of them that we're going to have today, BIP, Behavior Intervention Plan, CIT, Crisis Intervention Team, FBA, Functional Behavioral Assessment, IDEA is the Individuals with Disabilities Education Act, IEP, Individualized Education Program, PA, Public Act, PBIS, Positive Behavioral Interventions and Supports, and PPT, Planning and Placement Team. And I'm going to turn it over to Sean. Thank you.
So we're going to talk about restraints and seclusions first. According to Public Act 15-141, which was effective July 1st, 2015, and then amended in 2017 and 2018, it addresses physical restraint and seclusion of students in schools. It applies to all students, not just students with disabilities. It requires crisis intervention teams, and there are specific training requirements, which we'll go into more detail. There were increased attention on this at federal and state levels. So there were really specific interventions and kind of specific attention paid to restraint and seclusion, both at the state and federal level. And we're going to be going into more attention as we go further through these slides. So the definition of a physical restraint is any mechanical or physical restriction that immobilizes or reduces the free movement of a person's arms, legs, or head, including but not limited to carrying or forcibly moving a person from one location to another. Physical restraint does not include briefly holding to calm or comfort, minimum contact necessary to safely escort a student from one area to another, medical devices, including but not limited to supports prescribed by a healthcare provider to achieve proper body position or balance, helmets or other protective gear used to protect a person from injuries due to a fall, helmets or mitts and similar devices used to prevent self-injury when a device is part of a treatment plan or an IEP or prescribed by a medical professional, or an exclusionary timeout. So when thinking of the use of physical restraint, no school employee shall use physical restraint on a student except as an emergency intervention or to prevent imminent or immediate injury to the student or another person. And that's important to remember. It has to be an emergency intervention. Physical restraint may not be used for discipline or convenience or as a substitute for a less restrictive alternative. Restraints may not be a part of a BIP, a behavior intervention plan, or as a part of an IEP. And prone restraints are prohibited because they restrict the airflow to the lungs. And so when we talk about prone restraints, those are when children are placed face down in restraint. So they're restricted completely. I'll turn it over to Virginia now.
Hello, everyone. I'm going to talk a little bit about seclusion now. The definition of seclusion is the involuntary confinement of a student in a room from which the student is physically prevented from leaving. Seclusion does not include an exclusionary timeout, which I'll touch on in a little bit, a couple slides down. Seclusion does not include any confinement of a student in which the person is physically able to leave the area of confinement, including but not limited to in-school suspension, and again, exclusionary timeout. Use of seclusion. No school employee shall place a student in seclusion except as an emergency intervention to prevent imminent or immediate injury to the student or another person. School employees are prohibited from using physical restraint or seclusion unless properly trained. Seclusion may not be used for discipline or convenience or as a substitute for a less restrictive alternative. Seclusion may not be used as a planned intervention in a student's behavioral and intervention plan, BIP, IEP, or 504 plan. Seclusion is not a place, but the act of confining in a room from which the student's physically prevented from leaving, not including a verbal direction to stay in an assigned area. It could be in any area, class, hall, office, etc. If room, not a classroom, is used for seclusion, there are specific limitations, right? Things to consider: size, the size of the room, the ceiling height, heating, ventilation, unbreakable window, clear line of sight for student to see out of the room. These are all critical considerations because again, this is a student who's being put in a room only as an emergency intervention. An emergency is an unplanned response, either physical aggression towards others, students, staff, kicking, punching, biting, or self-injurious behavior, cutting, head banging. Non-emergency situations include throwing objects not directed at any one person, leaving an area, commonly, some children elope, tipping chairs, destruction of property, roaming, running around the class, inappropriate vocalization, swearing, refusals, and non-compliance. Those are all non-emergency situations where obviously seclusion would not be appropriate. Exclusionary timeout. So an exclusionary timeout is a temporary, continuously monitored separation of a student from an ongoing activity in a non-locked setting for the purpose of calming such student or de-escalating behavior. District policies in place by January 1st, 2009. They were to be in place by that date. It's not, exclusionary timeout is not a form of discipline, but prohibited as a planned intervention, but a proactive strategy to prevent restraint and seclusion. Expressly excluded from the definitions of physical restraint and seclusion, and an exclusionary timeout must terminate as soon as possible. It's very temporary. At least one school employee must remain with the student or be immediately available to the student to monitor that the student and school employee are able to communicate verbally throughout the exclusionary timeout. The space used for an exclusionary timeout must be clean, safe, sanitary, and appropriate for the purpose of calming such student or just de-escalating the student's behavior. And this part is really important. An exclusionary timeout becomes a reportable seclusion if or when the student is physically or otherwise prohibited from leaving the space. And I'm going to add to that caveat by saying that the Office of the Child Advocate does receive concerns from wide spectrum of issues. But what we sometimes hear about is that students are being put in what districts are calling an exclusionary timeout, but they are not able to leave. Well, how are they not able to leave? There might be a staff member blocking the doorway or blocking the passageway. And so the student knows that they are not able to leave. So that's an important distinction. And it is something that we do hear frequently, and we are very involved in trying to, sort that out a little bit. If a student is requiring special education as defined in section 10-76A, or being evaluated for special education pursuant to section 1076D and awaiting a determination, and the interventions or strategies are unsuccessful in addressing the student's any problematic behavior, the student's planning and placement team shall convene as soon as practical to determine alternative interventions or strategies. Exclusionary timeout is the most restrictive timeout. The student cannot observe ongoing activity if in class, and observing activities then inclusionary timeout. May be engaged in de-escalation procedures. Exclusionary timeout removes the student from all reinforcers by being placed in a different room. If not an effective intervention, consider an FBA to document the nature, duration, location, or other procedures that can be used. And I'm now going to turn this back over to Sean.
So I'm going to be talking about the monitoring of restraint and seclusion. So when a student is physically restrained, you're going to be continuously monitoring that student in a physical restraint. When someone is involuntarily secluded, there is frequently monitoring that student. That student cannot be locked in a room and left alone, but there's going to be frequent monitoring of that student by staff. As far as procedural requirements for restraint and seclusion, emergency interventions should be limited to time necessary for the student to compose themselves. So you want to have the student either restrained or secluded just for that amount of time that it will take for that student to come back to baseline, to compose themselves, to rejoin the classroom, and to come back to the activity in which they were removed. If the restraint and the seclusion exceeds 15 minutes, there must be a determination as to whether continued use is necessary as an emergency intervention by an administrator, a school health or mental health personnel, or a board-certified behavior analyst trained in restraint and seclusion. And a new determination must be made every 30 minutes. In thinking about meeting requirements for restraint and seclusion, when restraint and seclusion is used on a student 4 or more times within 20 days, when thinking about a general education student, an administrator, at least one teacher, a parent, and any mental health professional need to conduct a review of the student's behavior assessment or behavior intervention plan if one exists, and determine whether that student requires a referral to special education. If the student is a special education student, then a PPT must be convened to conduct a review of the behavior assessment that exists for that student, or to create and review a behavior intervention plan and review that student's IEP. Thinking about notices to parents regarding restraint and seclusion, the district must attempt to notify the parent of a student who's been restrained or secluded on the day of or within 24 hours after the emergency use of a restraint or a seclusion. This notification can take place by phone, email, or other method of communication, which may include sending a note home with the child. A copy of the incident report can be sent home or must be sent home no later than 2 business days after the physical restraint or seclusion to the parents, as I said, within 2 business days after the incident. Other documentation requirements for restraint and seclusion include the nature of the emergency, attempts at de-escalation, detailed description of the nature of the restraint or seclusion, the duration of the incident. Additionally, policies are typically available on the district website or in procedure manuals related to restraint and seclusion. I'll turn it back over to Virginia.
Thank you, Sean. So I'm going to talk about the crisis intervention team. The crisis intervention team consists of a trained teacher, administrator, school paraprofessional, or other school employee designated by the school principal and who has direct contact with students. Teams will respond to any incident in which the use of physical restraint or seclusion may be necessary as an emergency intervention to prevent immediate or imminent injury to a student or to others. Each member of that crisis intervention team is required to be certified or recertified annually on prevention strategies as well as the proper use of restraint and seclusion. Training for the crisis intervention team must include an overview, of the relevant laws and regulations regarding the use of physical restraint and seclusion on students, de-escalation strategies and prevention of the use of restraint and seclusion, the proper means of physically restraining or secluding a student, including, but not limited to, various types of physical restraint and seclusion, the differences between life-threatening physical restraint and other varying levels of physical restraint, the difference between permissible physical restraint and pain compliance techniques, and monitoring methods to prevent harm to a student who is physically restrained or in seclusion.
Please leave your message for 8.
Thank you, Virginia. So in addition to the Connecticut Restraint and Seclusion laws, we also wanted to talk today about the laws under the Individuals with Disabilities Education Act, or IDEA. The IDEA guarantees that students with disabilities have a right to a free, appropriate public education, otherwise known as FAPE. FAPE in a student's least restrictive environment is a cornerstone of the IDEA. FAPE looks different for every student, and each planning and placement team will design their individualized education program based on their unique needs and determine what specialized instruction and supplementary aids and services the students need. So the Individuals with Disabilities Education Act lists 5 special factors that all PBTs must consider. And one of these special factors is behavior. So every planning and placement team, regardless of what the student's disability category is, they have to consider, does the student's behavior impede their learning and or the learning of others? If the answer is yes, the team must consider the use of positive behavioral interventions and supports and other strategies that address behavior. And we'll talk a little bit more about that in a couple of slides. In Connecticut's Individualized Education Program form, this section is called Special Considerations, and they will document if IEP goals and objectives will be developed to address the behavior, if a behavioral intervention plan has been developed, and if other supports will be implemented. So for those of you who are not familiar with positive behavioral interventions and supports, it is evidence-based framework, a tiered framework for supporting students' behavioral, academic, social, emotional, and mental health. And it's important to know that students do not need to be in special education to receive tiered supports. Tier 1 is generally supports that are for everybody. Tier 2 has more targeted supports for students who might need a little bit more help. And for students that really need more intensive and individualized support, there's Tier 3 supports available as well. But for students whose behavior is impeding them, there is a requirement that the teams consider positive behavioral interventions and supports that the student needs. So this part, the functional behavioral assessment and behavior intervention plans are so important and critical as part of this process for preventing restraint and seclusion that we are going to spend most of session 3 on this. So we're just going to kind of touch over it here because we want to use data to make decisions for planning for our students. And an FBA is an assessment that looks at the function of the student's behavior. So given the nature of what's happening in their environment, collecting data to determine the possible causes and helping identify strategies to address the behaviors. A behavior intervention plan should be developed with the information that we have from our assessments, like the functional behavioral assessment. And it really should help the team develop strategies, program, or curricular modifications and supplementary aids and supports to teach the student the appropriate behaviors and eliminate the behaviors that impede their learning or the learning of others. It should be positive in nature rather than punitive, and it should be developed as a result of the functional behavior assessment. So these are just some other ways that we can support students' behavior. We're not going to go deep into it today, but teams should consider if the student needs specialized instruction and targeted IEP goals and objectives specifically to help them with those behaviors. Some of the related services, and thinking like for the whole student, we're not just thinking about just the behaviors, but behavior is communication. So does the student have communication needs that need to be addressed? Do they need speech services? Parent training is a related service that is often underutilized. So if the team creates a behavior intervention plan, it can sometimes be helpful for families to understand how can they support that at home and use the same language that they're doing for the student. Sometimes students might need help with emotional regulation, so music therapy or occupational therapy, and counseling are all other related services that can be helpful. And the team should also consider what accommodations, modifications, or assistive technology can help the student with their behavior, as well as adult support. And we talk about these things as these are the supplementary aids and services to keep a student in their least restrictive environment. So if a student needs adult support to be able to stay in the general ed classroom, that could be direct one-to-one support from a paraeducator or a registered behavior technician, or it could be just support in certain areas, or indirect adult support would be for the team. So not just supporting the student through direct services for the student, but the team might need consult time with a board certified behavioral analyst or other type of specialist that can help them to implement the IEP. So we could really do a lot of key takeaways. So I wanted to do a lot of slides on it, but we're just going to take a few away from the law today. Is really restraint and seclusion must only be used as an emergency response to prevent imminent or immediate injury to the student or another person. Physical restraint and seclusion may not be used for discipline or convenience as a substitute for a less restrictive alternative. If a student is restrained or secluded 4 times in 20 school days, it does trigger meeting requirements. Under the Individuals with Disabilities Education Act, planning and placement teams must consider behavioral needs of special education students in the IEP, and restraint and seclusion cannot be part of a behavior intervention plan or individualized education program. Virginia or Sean, did you want to add anything else to that?
I think you covered it, Jen. I think those are really key takeaways as far as this is considered. So I think that really covers everything.
And I did want to, there was one other point we wanted to make today about Board of Education policies. Sean, I didn't know if you wanted to speak to that and what policies were also part of the law requirements for exclusionary timeouts. We were going to add, we didn't add it onto the slide, but we wanted to mention that boards of education are required to have policies.
Oh, that's right. Related to exclusionary timeout.
Yes.
I'm sorry.
I'm talking too fast. So if you don't know your Board of Ed's policy, you should look that up and see when the last time it was updated, but it's really, again, intended for students, families, and all stakeholders to know what the policies are regarded to that in their district. You can go to the next slide. So, like I said, this is part 1 of 3. Our next session is going to be on documentation requirements for restraint and seclusion reports and best practices for family and school communication. And we will talk about what that looks like in the new Connecticut Special Education Data System and how we can use, if we use appropriate documentation and high quality information, it can help us to plan better for the student and supporting their behaviors through these challenges. In session 3, we will have a board certified behavior analyst coming from a district that will help talk about supporting students in the classroom by applying functional behavioral assessment results to inform function-based prevention. And I know that there's going to be a lot of questions that will be coming from these sessions. If you have questions, you can pop them in the chat. We may not get to them in each session, but we will be creating a document to answer some of the questions, the frequently asked questions that we get throughout this session. And for those who might have questions related to a specific student, a specific case or situation, we just wanted to share these resources with you. The Connecticut Parent Advocacy Center, the Bureau of Special Education Call Center, and the Office of Child Advocate. We will be sharing when we send out the PowerPoints, we will share the registration information for the next sessions. The next one is on March 27th. They are, and the other one I think is April 2nd or 3rd, but they're all on Wednesdays like today from 12 to 1. And everything will be recorded and put on our YouTube channel as well. So it will be accessible in multiple languages if people select the captioning option on YouTube. And I don't know, Sean, did you want to add anything?
The goal also is, we had talked about creating a document. So if people do have questions, we do want to create a document also related to people's questions related to restraint and seclusion. So it's going to be a joint document between our agencies to answer anybody's questions so that you have something tangible to walk away with that may be helpful. Specific to restraint and seclusion. So we can answer questions so that you could walk away with something that, may be helpful for people.
And I'll just add to that, families who have concerns related to restraint, seclusion, or educational programming, the Office of the Child Advocate, our contact number is up there. We have an intake coordinator who takes all concerns, and then it is a multidisciplinary agency. Those concerns are reviewed, and either, we can either provide resources. Sometimes we take a deeper look, and sometimes we even take a really broad look, depending on what the issue is. But we always try to help as many families as we can. Again, even if we're just providing resources, or, if we can do more, we will. But we are a resource. So.
Thank you, Virginia. And is that the last slide, Laura, or do we have another one on there? Okay, we can check those. Thank you. And I see that we do have some questions in the chat about the dates again, March 27th at 12 o'clock and April 3rd at 12 o'clock.
Yes, April 3rd.
And the registration will be shared with you via email. It'll be posted on CPAC's website, as well as our social media. So we'll make sure that we get those flyers sent out to the districts as well, and ask that you share those with your families and your staff. And there is a question. Can I ask a question, Sean? I'm not sure if you'll know the answer to, but there are several questions about Can Parents See the certification? And I believe they're referring to the crisis intervention teams.
So what you can do is you could go back to your district. Staff are required to be certified. You have a 1 year, your certification is valid for 1 year. You can go back to district. So if you receive a restraint report or a seclusion report, you can go back to your district and ask to verify that the staff who did the restraint or seclusion were certified, and just to verify that certification in the district. So making sure that their certification was current.
Thank you, Sean.
Yep.
Are you okay with taking another question before we
Sure.
head out? Maria, she put a question in about what are the new law policies on restraint and seclusion in the city of Bridgeport. So we aren't gonna go into specific districts. If your Board of Ed policies should be posted online. And if not, you can request it from your district, but each district doesn't have their own law on it. They're supposed to have a policy that's aligned with Connecticut's existing laws, if that helps make sense. And there's another question about what happens when they are not certified.
So if a staff isn't certified, then you have the right to file a state complaint, and we would be able to do an investigation related to that. We do conduct investigations if a student was restrained or secluded, and there wasn't a staff that was certified who conducted that restraint or seclusion. So we have a due process unit, and we would conduct that investigation.
Thank you. All right. CPAC staff was monitoring the chat. Did I miss any? Oh, are injuries automatically reported is another question.
So injuries are a part of the whole restraint or seclusion document, and so they would be reported. We also have a specific requirement by state statute around serious injuries. So I monitor serious injuries, and they have to be not only reported to us, but they also are reported to Disability Rights CT. So any child that sustains a serious injury, they are reported, and also Virginia at the Office of the Child Advocate gets all reports related to serious injuries.
Thank you. And can I have one of our bilingual staff read the Spanish question that's in the chat or comment?
Yes, absolutely. And it's from Jedney, and Jedney says, I have a child with autism, and he participates, I'm sorry, and participation is very difficult for him as well as communication. My question for you is, how can we help him? Can we, again, have a one-on-one for him, or someone who can monitor behavior? And also, how do professionals work with my child?
I would have to say, I would probably reach out to the director in the district regarding this issue. It sounds to me like, there's some concerns related to your child, and I would definitely speak to the director for the district regarding this. Every district has a director of special education, and it sounds like there are definitely some concerns that you have. So I would reach out and just say, you'd like to schedule a PPT and see what additional services you could put in place.
And also, if you reach out to CPAC, we can help talk through individual cases. So if you have concerns related to your own child or another specific student, if you're a school staff on here, you can please reach out to the resources that we shared on the last slide. So there's a question in here about what are laws for restraints and transportation. And Lisa, I don't know if you would like to explain that a little bit, what you mean by that. And I don't know if you're able to unmute what is allowed in transportation. Okay.
Lisa, if you can, why don't you and I, it's like a more detailed question. So I probably want more information related to it. So why don't you and I connect related to this? If we can. So.
Thank you for putting those slides up, Laura. So another person's asking, what are the laws around the restraint on a bus or a van? And are they different than having a restraint in the school?
So no, they would be the same because it's transportation. And so again, I'd be happy to touch base with you regarding it. It's more along the lines of who's trained to do the restraint. You have to have someone able to do the restraint. And see, Mary wrote, and that's true, seatbelt covers to prevent the child from being restrained. So you're hoping that the child is in a seatbelt, and who's actually doing the restraint. You want to make sure that if someone is restraining a child, that they have to be certified to do the restraint. So I'd want more details related to the restraint. Is the monitor certified? That's one of the things I'd want to know. So I'd need more details related to it. There's a lot of open-ended questions I have related to the specific situation.
Thank you, Sean. All right, so I think we've gotten most of the ones in the chat. And as for the questions, if there's any we didn't answer here, you can please feel free to email us or call us at any of the numbers that we've provided. And we are happy to help you answer your questions. And we look forward to seeing you at sessions 2 and 3. So have a good afternoon.
Thank you so much for participating today.
Thanks, everyone.